welcome today, everybody, to our Handling Grievances for Effective Outcomes virtual boardroom that's been facilitated by HR Recruit and Nathan Andrews from Akana. My name's Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Nathan, who will introduce himself shortly. Nathan is going to draw on his professional experience of handling complex grievances and also share tips and best practice in handling the grievance procedure. If you've got any burning questions during the session, then please put them into the chat box facility. But as there's a lot of content to go through, we have allowed time at the end for a Q&A session. I'm now going to hand you over to Nathan, who will introduce himself and start the session. Thank you.
Thank you, Jo. Hello, everyone. As Jo said, my name's Nathan. I'm the Managing Director for a company called Akana. So we're a small consultancy firm that specialises in employee relations. So there's myself and I've got two colleagues that work with me, John and Deborah. And as I say, our work is really focused on supporting client organisations, which can range from SMEs up to large organisations. In fact, our demographic of clients has changed. We're working with now bigger size companies and we support them on a full range of ER matters. And funny enough, September going into October seems to be a period where grievances are at the fore of the work we're doing. So we've got a lot of grievances on at the moment. So I might be able to share some helpful hints and tips as we work through. What I'm going to do is I'm going to share my screen. Jo, can I share with you? Have I got sharing permission?
Yeah, you have, yeah.
Perfect. Right. So if I share that, and then I'll just sort my slides out.
I can see that.
Can you see this screen here?
Yeah.
With my cursor maybe? Yeah, perfect. Okay. Bear with me, why is it frozen on me? There we go. You should be able to see my front slide, Jo. Can you see that?
Yeah. Yeah.
Super. Okay, good. So we know that we are on track. So today's session is really going to be about talking about the grievance process and sharing knowledge and hints and tips. I appreciate that probably the majority of you on the call are all HR professionals, will all have your own sets of experience as well. So feel free to share at the end and of course answer any questions that you have. What we're going to cover today, because I appreciate this is quite a short session, but we are going to look at how a grievance is defined. We'll talk about the ACAS code. We'll then look at how to respond when you receive a grievance. We'll talk a little bit about the investigation process. The grievance meeting itself will cover the right to be accompanied, and then the outcomes. That's when you're finding resolutions to any complaints that your employees have made. So the first thing we'll talk about is how a grievance is defined. Now, lots of clients that we work with sometimes have the impression that there is a legal definition for a grievance, and actually that isn't the case. There is no legal definition. But what we do know and what we do say to clients is that a grievance isn't a grumble, and it's not somebody having a whinge on a Monday morning in the kitchen or by the water cooler. It is they have typically significant concerns. It might be relating to their terms and conditions of employment. It could be to do with working relationships with their line manager or work colleagues, for example. So a grievance is very much something that is significant, and it's not something that is just essentially a minor concern or a minor complaint. And I think it's really important that we always bear that in mind when we're dealing with employee issues. We've dealt with a situation recently where a client was dealing with what I would consider to be a minor complaint, and they offered the employee the right to raise a grievance, and the employee then raised a grievance, and actually the grievance procedure wasn't really the right forum to deal with the issue at hand. So again, we worked with that client just to talk through this process around what is a grievance and how is it defined. We always say if you have an employee who's raised a grievance, then that should be treated seriously. So if they're raising significant concerns, you should deal with that appropriately, and you should essentially follow your grievance procedure at the point that you are aware that an employee is unhappy. So if you're following the ACAS code on disciplinary and grievance procedures, there is an expectation that the employee will put their complaint in writing, and I think that is important. However, we do say to clients, don't get overly hung up on that and the early stages of being aware of a complaint. We also say that clients need to be aware that issues that don't necessarily fit into a neat box, such as a letter or an email that says with the subject line formal grievance, don't overlook complaints that employees may be sharing with you verbally. So what we say to clients is, if an employee comes to you, they're unhappy, they're making concerns about the relationship with their line manager or with work colleagues, you certainly want to explore that with the employee, and you would then later on encourage them to put their complaints in writing. Now, an important point to remember is that an employee's obligation to resolve or deal with a grievance doesn't actually require you to deal with the matter to the employee's satisfaction. All that is required is for the grievance itself to be resolved and dealt with fairly and reasonably. So we work with clients who sometimes will think that they have to find in favour of the employee's complaint, and actually, as most of us will know who are practicing HR professionals, that isn't the case. What we need to do is to understand the complaints, investigate appropriately, and follow the information, the evidence that is available to us when we're making conclusions. We often get asked by clients, does a grievance have to be dealt with? And we will say the good practice answer is absolutely yes. If ignored, complaints can fester and they can become more serious. There are, of course, legal risks in ignoring a grievance. For example, the employee could go on to resign and make a claim for constructive dismissal. If your grievance procedure is contractual, and we advise that grievance procedures shouldn't be contractual, then a further claim for a breach of contract could be made in those circumstances. An employee could also claim that you've ignored their grievance on the grounds of discrimination, or that whistleblowing or some other protected characteristic was at play, which essentially influenced your approach or behaviour in handling their complaints. So the ACAS code, as we all know it, I'm not going to go into a deep dive in this because I know that the majority of people attending today will be very familiar with the ACAS code, but the ACAS code of practice is a statutory code approved by Parliament. Failing to follow a code of practice does not necessarily mean that you will have acted unlawfully, depending on the circumstances, of course. However, if you find yourself dealing with a claim in the employment tribunal, then they will take into consideration any lack of adherence to following the code of practice itself. So it's something we recommend to our clients that they always give consideration to, which is, what does the ACAS code of practice say? Let's make sure we follow that as a means of good practice. Again, failing to follow the code of practice could result in an employment tribunal increasing any compensation award by up to 25%, or they could, of course, decrease it by up to 25% in a case where an employee has unreasonably failed to follow that code. So the general principles of the ACAS code is that the employee should let their employer know the nature of their grievance. They should give you detail and give you context so you are fully aware of the situation and what their complaints are about. As an employer, you should then hold a meeting with the employee to discuss their grievance. You should then allow the employee to be accompanied at that formal grievance hearing. So that is their statutory right. The employer should investigate the employee's complaints, and the investigation is key, something we talk a lot about in our work with our clients. We often will handle workplace investigations on behalf of clients when dealing with grievances, and I'll talk a little bit in more detail about our approach in that regard, but an investigation is always key. As an employer, you should then decide on the appropriate action that you're going to take following your investigation, and any decision making should be based on the evidence that you have found, and you should be able to refer back to that evidence and objectively justify your decision making process. And finally, as we know, you should allow your employee the right of appeal if they are unhappy with the outcome of the grievance, bearing in mind that, as we said earlier, your obligation is not to find in the employee's favour. It is for you to investigate and treat their grievance reasonably and fairly, taking into consideration the evidence that you gather along the way. So in terms of responding to a grievance, we talk a lot about the ACAS code, and we advise our clients, if it's not possible to resolve a grievance informally,
Nathan, I think you're on mute.
Nathan, can you just unmute yourself? Sorry.
Did I do that? Was that my?
I'm not sure. I don't know. Sorry.
I'm not sure how that happened. I apologise. I will go back to the start. What we always say is if it's not possible to resolve a grievance informally, then employees should raise their matter formally with you, and they shouldn't delay in doing that. So ideally, when I'm handling a grievance situation with the client, we will look at the situation and we'll look at the nature of the complaint, and we will make a decision about, can this be dealt with reasonably in an informal way? And if it can, we will take that approach and approach the employee and say, look, we've looked at your complaint, we think we could deal with this informally, we might make some suggestions about how we could do that, and then we will take a viewpoint from the employee. Now, if they wish to raise their grievance and have that treated formally, then what we would say is that they should submit that issue in writing, and they shouldn't delay in doing that. There shouldn't be an unnecessary delay in them submitting that letter to you. Now, what we always say, and I touched on this earlier, is that we shouldn't get hung up on the initially on the complaint being in writing. It absolutely should be in writing, but early on, if someone is talking to you and they are verbally raising issues, then let's listen to that. Let's take down the detail, but then let's make sure that the employee puts that in writing. Now, I've dealt with situations where we've had employees who aren't confident about putting things in writing for a number of reasons. It could be that they're in, we dealt with a situation recently where an employee had dyslexia, and so they needed support. So what we did in that situation was we listened to their complaint. They were able to verbalize that. We recorded that in writing, and then we presented that back to the employee, and they signed to confirm that what we had recorded formed the nature of their complaints. And then what we did was inform the employee that those issues that we had captured, they would be the issues that we would investigate, and they would be the issues that we would address. We always say that there's no value in arguing that an employee has not raised a formal grievance because they didn't label their complaint as such. So, for example, if you have an employee that sends you an email but it doesn't have in the subject line grievance, there's no point in arguing that potentially that employee wasn't raising a grievance. We need to apply common sense. You will clearly be able to see if an employee is raising complaints, and if they are, then we should treat it as a grievance. Again, depending on the seriousness of the nature. If these are minor issues, then yeah, I wouldn't automatically go to the grievance procedure. But if the complaints are significantly serious enough, then we should absolutely invoke the grievance procedure and follow that as set out in your own policy. Now, if an employee hasn't put their complaint in writing, absolutely, once if they verbalize it to you, ask them to do so. Ask them to put the details in writing to you, because it's important to have a written record, absolutely, and it will allow the employee to build in structure to their complaints and their thinking and the points that they wish to make for you to consider. And then it gives you, or whoever's appointed to hear that grievance, a framework to follow so that they can cover all the relevant issues. My slide's frozen again. There we go. So on receiving a grievance from an employee, we absolutely say you want to appoint a person to handle the grievance. The person responsible for handling the grievance process is usually the line manager, unless they are the subject of the grievance itself. The grievance officer can also be someone more senior to the complainant's line manager, so it could be the line manager's line manager. They shouldn't be the most senior person in your organisation, as you will need to keep someone available to hear an appeal process. If you're working within a particularly small organisation, it might be that you can hear the grievance, but you might have to outsource the appeal to someone like myself, an independent HR consultant, who can give you support in those circumstances. If the grievance concerns a director or someone within your HR department, then we would normally advise that you should consider appointing someone externally to the business to handle that grievance process. The second point we make is to hold an investigation meeting with the employee who's raising the grievance, so that you can gather facts and be clear on the nature of the complaints that they are making. So holding an initial investigation meeting does not require you to give them the right to be accompanied, as that doesn't constitute a formal grievance hearing. So the right to be accompanied only applies when you are holding a formal grievance hearing with the employee in line with your grievance procedure. Now, that being said, if an employee does request to be accompanied either by a colleague or a trade union official at the investigation stage, I was advised recommending that you consider that request, because it might be that the employee has a disability and that they would find it easier to have someone support them. Our approach when we're supporting clients is always to kind of adopt a gold standard approach. So we will always, where we can, go above and beyond what maybe the ACAS code says. So for example, if we're investigating and someone says, look, I think I would benefit from having someone accompany me, I typically never have an issue with that if I'm chairing the process myself, and I certainly say to my clients, give that consideration. Don't just make a knee-jerk decision to say no. Again, as I touched on briefly, if the complainant is known to have or claims to have any disabilities, then absolutely, exercise your discretion in allowing them to be accompanied, because that can go a long way in you being able to defend a claim should you face the employment tribunal. Point 3 is that in addition to holding an initial investigation meeting with the complainant, is for you to write to them confirming receipt of their grievance and to set out what will happen next. And I think that can be particularly helpful in keeping all parties informed. So in your letter, what we recommend is that you include a summary of what you discussed during your initial investigation meeting with the complainant, provide a timeline concerning what's going to happen next, and when you anticipate being able to hold a formal grievance meeting with the complainant. So they are fully aware of what you're thinking, what you're going to do, and roughly when it's going to happen. And as I say, that can often go a long way in helping people to engage with you in a positive way, and for them to be confident in what you're going to do and how you're going to do it. So as I say, we're big fans of conducting a really thorough investigation process. We often handle investigations on behalf of our clients. So what we say at the investigation stage is identify the issues in the grievance and list them all in a summative format so you can refer to that later on. Now, we do that. We have a template document that we use. And so what we're able to do is to go through quite systematically through an employee's complaint. So for example, and we've got one at the moment where we've had a 6-page grievance letter, and they've raised something like 31 points to their grievance. And so what we've been able to do is break that down in a systematic way so we can look at each point in turn and do that justice through the investigation stage. So for each issue, think about who might have further information. So, essentially witnesses. And also think about, are there any documents that you will need to review as part of your investigation? And if there is, list them down against each issue so it keeps you organised and it gives you a framework to follow. One of the things we do when we work with client organisations and they appoint us to either investigate or hear a grievance is we issue an investigation plan. We have a standard template that we use. And what we do is we ask the client to fill that out, to complete that investigation plan as best as they can. And that then is returned to us, and that gives us a solid framework to work towards. So we will understand from that investigation plan, the client will give us an idea of the number of witnesses and who they are. They'll break down information that we need to review. So the one we've just had in 2 days ago listed CCTV imaging that we needed to review, a number of policies, there were a number of emails. So actually the client was able to have some structure to their thinking early on, and that's really helpful when you are investigating. Now, what we always say is if you aren't used to working with investigation plans, a good investigation plan should set out who the investigating officer will be, and that's an obvious one, but it should also set out the terms of reference of the investigation, and that's really important. Having a clear set of terms of reference gives you a solid framework, and it avoids the investigation becoming unwieldy and unmanageable. So we're dealing with a situation at the moment where a client has dealt initially with an investigation themselves. There was no agreed terms of reference. And so what's happened is you've had an investigating officer who has kind of almost gone on a fishing expedition, and they've looked at all manner of things concerning an individual's conduct. And now that individual is claiming constructive dismissal. And one of the issues they're raising is that actually this is a witch hunt, this is a fishing expedition. The company didn't have any valid concerns about my performance. That's why they have gone through and looked at, absolutely everything they could possibly find concerning my conduct. So had the client organisation we're working with had sufficient terms of reference, that would have helped them keep on track and keep to the most relevant issues that they were trying to address. A good investigation plan should also have a provisional timeline. Again, the timeline can move. It depends on availability of witnesses, maybe information or evidence that you gather that is larger maybe than you had originally anticipated or been led to believe. So we always say that a timeline is provisional. It's not hard and fast, but you should have a rough guideline of what you're looking at doing and by when. Again, identify all the relevant evidence, company policies, procedures you're going to rely on, the issues which need to be addressed, break down the evidence which needs to be collected, because, for example, if you're gathering CCTV imaging, that can sometimes take time. So again, it's relevant to capture that and to factor that into your timeline. Again, identify the people who need to be interviewed and give some consideration to how long you think those investigation meetings might need to last for. And you also want to have in mind the date the investigation should ideally be completed by. Now, it might seem an onerous process to have an investigation plan and to go through things in that way, but I've seen this, come into its own when you're potentially dealing with tribunal claims, and you can demonstrate the rationale and the approach you took to investigating your employees' complaints. So it is a worthwhile exercise. So the grievance meeting itself, this is fairly self-explanatory, and I'm sure most of you on the call today will do this as a matter of good practice. You absolutely want to invite the employee in writing to attend the grievance hearing. Make sure you offer them the right to be accompanied. When the employee attends, thank them for attending and extend that to their rep if they're being accompanied. If you have a note taker present, introduce your note taker and explain their role. If you're recording the meeting, make sure you tell the employee that you are doing so. As a standard practice for me and my team, we record all of our meetings, whether that's an investigation meeting, grievance or disciplinary. We adopt that approach now because typically we have found previously, if we're not recording, the employee is likely to be recording on a mobile device. So actually it makes the process more straightforward. If you record, you disclose that to the employee, you can offer them the right to have a copy of the recording, and then you can give them a typed up transcript at the end. What we do is we say to employees who are attending either a disciplinary or grievance meeting or an investigation meeting that we will be recording, and that what we will do is provide them with a transcript, and we'll ask them to review that transcript. And once we've approved the transcript, the recording gets permanently deleted, unless the employee says, I would like a copy of the recording. So that's the approach that we take. Again, at the end of the meeting, summarize the purpose of the meeting at the beginning, and then at the end, what I always recommend is that you provide a summary of the employee's grievance as you understand it and the key points that you've discussed during that meeting, just so you can capture that in your records and ask the employee to confirm that they agree, essentially. Absolutely ask the employee if they have any questions and any information they believe is relevant for you to take into consideration. And then what you would look to do is present the findings from your investigations. So if you've gathered evidence, you can present that to them during the grievance meeting and ask them to comment on that. Ask the employee any questions for clarification. That's really important. So if you've got information that you're not certain about, or you have further questions, make sure before you go into that grievance meeting that you are prepared and you have your questions set out, just so you can capture the additional information you're looking for. Again, as I said previously, summarize what's been discussed and then explain to the employee that you will be adjourning to consider your findings from your investigation process and their responses during the grievance meeting. So we're always very specific about that. When we adjourn to consider the findings from the investigation, we also say to the employee or the complainant that we are going to take into consideration the responses that they made during that meeting, so that they're aware that it's not just the evidence we gathered, it's also the information they shared with us during that grievance meeting. Again, I'm not going to go into any detail on this because I appreciate that you all know that employees have the right to be accompanied, and that it is a statutory right to be accompanied by either a fellow worker, so a colleague, or a trade union representative. What we always say to our clients when we're working with them is that if the complainant is disabled and their disability impedes their ability to understand or engage in the grievance process, then you absolutely want to make sure that, especially if they're saying no, they're happy to continue on their own, just make sure you cover off with them. Are you sure you want to continue? Are you sure you don't want to have somebody present with you? Additionally, certainly if you're, and this is an important point to cover, is if you're handling an investigation process, if you're dealing with a complainant who's under 18 years of age and you're initially meeting with them to understand the nature of their complaints, we will typically say do you want to bring, your parents with you, for example, or a worker or trade union representative? But we will be reasonable, given that if they're underage, it's often helpful if they want to be supported by their parents. We've dealt with a situation recently where a complainant's mother attended with them. And then what we did is we were very boundaried, and we set out their role in being in attending that meeting, so they understood the kind of the do's and the don'ts, essentially. Does that all make sense so far? Yeah, okay. We are nearly there. The outcome of the grievance process, and this is a really important point. So following the meeting, you need to decide on what action, if any, that you're going to take. So your decision should be communicated to the employee in writing. There shouldn't be an unreasonable delay in doing that. So manage expectations early on. If you think it's going to take, and certainly in a complex matter, and again, you need to refer to your grievance policy, but most grievance policies that I see will say that the outcome of grievance will be communicated within 10 working days. That should give you sufficient time to communicate that outcome. If it is a particularly complex matter, then what we recommend is, and you think you're going to need longer than what's stipulated in the policy, communicate that to the employee and explain the reasons why, and then seek their agreement, especially if your grievance procedure is contractual. As I say, we recommend that your grievance procedure shouldn't be contractual, but in circumstances where they are, you need to make sure that if you are varying that you seek agreement with the employee. You also need to set out what action you will take to resolve the employee's grievance, and they should then be informed that they can appeal if they are not happy with the outcome. So that is really important. So after attending the grievance meeting and then adjourning and explain to the employee you're adjourning to take into consideration the information they presented to you and your findings from the investigation, what we say is that you should work through the checklist, and this is a checklist that we use, and it's again very obvious if you're working in HR, or in an HR role. So we say, what was the original grievance about? So when you're preparing your grievance outcome letter, it's really important to follow this and to be clear on what the complaints were about. And again, if you follow the advice I gave earlier around breaking down the nature of the complaints, if you have a long grievance letter, and that can often be the case, break down into relevant points the nature of the complaints and deal with each one in turn. Again, now that you've investigated fully, you want to consider, has the grievance been refined or altered in any way? Again, you want to be clear on that and make note of that, because again, it keeps you on point. Make a list of all the evidence you've gathered which supports the grievance. And again, we do this if we're working on behalf of the client. We'll prepare a grievance outcome report, and we put into the appendices the evidence we've gathered and that we're referring to in our outcome communication with the employee. Again, based on the information gathered from the investigation, you need to consider, is there a grievance to address? And remember that you should be analytical and consider everything which is relevant. So sometimes we will investigate a grievance and find actually there isn't a case to answer, and we'll communicate that appropriately. But often, as is the case, we'll find that there is points to be upheld, and then we will be very analytical in our approach in terms of how we look at the evidence, and we'll refer back to that when we're setting out our findings. And we do that, and again, in a very systematic way. So as we work through our investigation process, as we gather evidence, we code that evidence early on, and then we include that in the appendices, and we will refer to that in any outcome documentation that we issue. If the grievance is not well founded, you need to consider how you explain this to the employee while still being supported. And again, it's all about being clear and writing that down in terms of what you're going to say, so that when you do meet with the individual or you do write to them, you are clear on the points that you wish to make. And then if the grievance is well founded in your opinion, you then need to decide what you're going to do to address that. Now, you can do one of two things. I mean, I personally like to reconvene. So once I've taken an adjournment, I like to reconvene a grievance hearing at a later date and communicate to the person who's making those complaints the decisions that I've reached concerning the outcome of their grievance. And I like to do that because it gives them an opportunity to ask me questions. I do, of course, absolutely confirm the outcome in writing. So, you know, when I reconvene, it's not an opportunity for the employee to try and change my mind. I go back in after having looked at all the information available to me, and I will make my decisions and communicate that. But I like to do that in person because I feel that's respectful. I have a colleague who will, they won't reconvene, they will write to the employee. And that's a pretty typical way of people handling grievances. But for me personally, I always find it better to sit and communicate that in person. And then I give them a letter. And of course, they have the right to appeal. Again, remember to allow the complaint to be accompanied to a later meeting if you are reconvening, because that is an extension of the original grievance hearing. So again, when I reconvene, I say to them, you can be accompanied. And that again is confirmed in writing to them. Always confirm the outcome of the grievance process in writing. And this is sometimes where we see clients, if they're handling matters themselves, kind of fall over. They could have handled the process perfectly. Then they get to the outcome letter, and the outcome letter can sometimes be 1 page or 2 pages when they're responding to a 6 or 7 page grievance letter. So then what we would typically do is then work with the client to expand on the points they're making so that the individual who's made the complaints can clearly see how the organisation has reached the conclusions it has. So make sure that any letter that you issue to an employee confirming the outcome of their grievance, that is sufficiently detailed enough for them to be able to understand your thinking. Now, the outcome letter is a particularly important document and one that an employment tribunal will place the most weight on if a claim for constructive dismissal or discrimination is made. So that's why it should, you shouldn't rush that process. You should give it the time and consideration it needs for you to be able to appropriately respond and set out your findings. And again, always offer the right of appeal. Again, for the majority of you as HR practitioners, you will do that automatically. We work with clients who don't necessarily have the HR support in-house that other organisations do, and that's a point that they can often miss. So it's just an important point to always remember. Excuse me. And that is the end of the presentation itself. It was a bit of a whistle-stop tour, but I wanted to allow time for questions.
There's a few things in the chat box, Nathan. So Alexis asked this was quite early on, so we may have ended up covering it anyway. She said a computer was crashing. So when appointing a person to handle the grievance, should that be a HR person or line manager or someone else?
No, I mean, it doesn't have to be an HR person. In fact, in an ideal world, it would be, as long as the line manager isn't the subject of the grievance, it would be the line manager that would handle that process. Obviously, if the line manager is the subject of the grievance, then it should go to somebody else. It could be the line manager's line manager, or it could be HR, or it could be another manager. If you've got a fairly well-established management infrastructure, you could pass it to another department manager, for example, to deal with. So it doesn't have to be HR that owns that process.
Okay. We've also been asked, can you confirm what you consider a reasonable time for someone to raise a historical grievance, as a long time can pass and people's memories of events become less clearer?
Yeah, so we dealt with a situation recently where an employee raised, it was a very complex matter. Their grievance letter itself was something like 14 pages, but they were raising matters going back 3 years. And what we said was that actually it wasn't reasonable for us to go and investigate issues from 3 years ago. We said that we would restrict the time to a 6-month period, because that was more reasonable for us to be able to do it, do an investigation and understand what took place. They raised a subsequent complaint around that, but we just said it wouldn't be practicable for us to adopt that approach. People's recollections of what occurred 3 years ago would have faded. Any evidence we gathered, you could potentially argue, maybe would have been compromised because of the time period. So no, we always say, a 6-month window, fine, but if you're raising things going back years, then that's not reasonable.
Judeline's asked, can you say something about the investigation officer hearing having appropriate training in issues of discrimination and UB?
Well, if I touch on, this is a really important point and something we talk a lot about in our work, is that if you're appointing someone to either chair an investigation process, a disciplinary process, or grievance process, they should be ideally trained to be able to handle those processes. Now, I appreciate not every organisation necessarily provides that level of training, and if that is the case and you've got an HR department, then it would then fall to the HR individual or representative to support that line manager, not necessarily do the doing, because if you've appointed a line manager to chair or oversee a workplace matter, they are the ones that should be managing that, and what you can do as an HR professional is advise and guide them in line with employment law and your own internal policies. So absolutely, training is really important, and I would say it's particularly significant when you're handling investigations. And we're dealing with a matter at the moment where if an investigation was initially undertaken by the organisation and the person that did that didn't have any training, and now we've got, they kind of embarked on this fishing expedition, which has caused other issues. So again, it is really important to make sure that your management population has the right training to be able to deal with those issues. I think you said something about discrimination, Joe, at the end of that question.
Yeah, it just says indiscrimination and UB.
And newbie?
I wasn't sure. UB. I didn't know what that meant, but that could be me being ignorant.
No, I'm trying to think what that means off the top of my head. Feel free to elaborate. And
I thought that was me.
No, it might be. I can't think UB. It's going to be something really obvious. I'm going, oh yeah, we all know what that is. I'm happy to come back to that, but yeah, training absolutely essential. If you've got managers who you expect to look after those types of processes internally.
Oh, unconscious bias.
Oh, yes, unconscious bias, absolutely. Yeah, and that is really important. Again, lots of clients we work with don't or haven't embarked on training around unconscious bias, for example, and it's the sort of work that we do when we provide training workshops around handling things like grievances, investigations, and so on. So again, for us as HR practitioners, we're really aware of all of this stuff, but for a lot of line managers, they're not. They might be technically very capable in terms of what they're responsible for and the department or the work that they're responsible for managing. But when it comes to the people practices, I always think it's our jobs as HR practitioners to share knowledge and to upskill them. Because in an ideal world, line managers would pick up these processes and we would be there to guide and influence, but we wouldn't necessarily have to do all the doing.
Mm-hmm. Okay. Vicky's asked, so is the investigating officer the same person who would chair the formal grievance hearing or someone else? Yeah,
so it can be the same person, and normally it is. So we will deal. So if I get some clients who will appoint me as the chair of the overall grievance procedure, and I will investigate and hear the grievance. I have some clients who like us to do the investigation and to write an investigation report, and then they will appoint a grievance chairperson or a grievance officer to then take away our report and the evidence we've gathered, and then they will then meet with the employee to hear the grievance. Typically, our preference is that we would have one person kind of oversee that process. I just think it's cleaner that way. But there's nothing wrong if you want to get somebody independent to do the investigation. It just means you've gone through an extra layer that actually could potentially offer you a level of protection should matters become more contentious later on.
Another one. So are you saying there should be a grievance investigation meeting with the person who's raised a grievance and then a grievance hearing? Or is it the same thing, just the grievance hearing is adjourned whilst you investigate?
No, so I like to, and apologies, I probably didn't make that very clear. So I like, my team, we like to hold an investigation meeting initially with a complainant, and we treat that separately to the grievance hearing. The reason we do that is if they've given us, a letter setting out various issues, we might have some questions and we want to gather some information. So we'll meet with them at an initial investigation meeting, gather the additional information we need, and then we'll go and set about conducting our investigation. And once we've done that, we will then meet with the employee at a grievance meeting and talk through our findings, present them the evidence that we've gathered and ask them to comment on that. And then I will adjourn and go away and consider any responses they've made in part one of the grievance hearing before I reconvene and communicate my decision. And sometimes I don't do that. I don't reconvene on the same day. So often we do it later on. It might be 2 or 3 days later because I want to review, condense down what I've gathered and so on. But again, I've got colleagues who work with me who they would accept the employee's grievance letter and say, well, that's what I'm going to investigate. And they will meet with them at a grievance hearing and they'll discuss it all in one. But for me, I like to gather as much information early on before I meet with them at the formal part of the process.
Okay, so What do you suggest telling the employee when their grievance is founded and their allegation is in relation to someone else, bearing in mind the other person's process is confidential?
Yes, I mean, what we do is if the evidence, supports the complaints that have been made, we communicate that to the employee. So we'll say to them that we're either upholding their grievance in full or in part. If it's in part, we tell them which parts are being upheld and which parts aren't, and we give them the reasons why. And then what we will say to them is that formal action will be taken with essentially the respondent, but we don't give them information about what that action looks like. So all they know is we're taking formal action, and then obviously we explain we can't share any more information in that regard due to our responsibilities for confidentiality to the other party.
Okay. Do we need to give the person who the grievance is against the grievance notes, in brackets plus witness notes, if it results in a disciplinary process?
Sorry, just say that again to me.
Do we need to give the person who the grievance is against the grievance notes and the witness notes if it results in a disciplinary process?
Yeah, so you would, any evidence you're going to rely on in a disciplinary process with the respondent, you would make that available to them. So yes, they would. So anything, if you're going to rely on the notes gathered from your investigation, your grievance investigation, then yes, you would give them copies of that so they had, they can essentially prepare their case.
Lisa's asked, is there ever a time the right to appeal does not stand?
The only time the right of appeal isn't necessarily applicable would be if you've got a short service employee potentially, where you don't necessarily have to offer them a right of appeal. But typically we would say that would apply in a situation where they've been dismissed and it was a short service dismissal. But we would always say when you're handling a grievance process, absolutely, obviously if you've got employees full employment rights, you give them the right to appeal, but ultimately you'd want to adopt best practice. And if you've heard their grievance and they're unhappy, they should have the right of appeal. And certainly if your grievance procedure is contractual, again, as I say, we always recommend that they're not, but I have got a handful of clients who had policies drafted for them that were contractual, and so they have, and including the right of appeals, they have to follow that, otherwise they face a breach of contract claim.
That Geordie's asked, she's saying she's got an investigation starting next week where a number of complaints have come in regarding behaviour from various people. Who would actually raise the grievance? Would it be the line manager or just the organisation investigating from a place of a duty of care to colleagues?
Well, it depends. Did the complaints come? Did the complaints come in independently, or has the organisation identified that there's potential issues? That would be my first question. I mean, essentially, if you've got 2 or 3 complainants, you could treat it as a collective grievance. So if it's related, if the issues are related, I'll let them come back on.
If you want to unmute yourself, Geordie, and answer that, that's fine. Okay, well, we'll carry on to the next one. We can come back.
Yeah, don't worry.
That's that one. So regarding reasonable time of historical issues, what if the employee has been absent for a year, for example, and the grievance is from before that absence?
Yeah, I mean, we've dealt with cases like that before where we would allow that in those circumstances. They've been absent for a year, but the time they went on sick leave, those issues were valid. The only thing I would sense check though is did they raise any issues at the time, so prior to them going on sick leave? And the other thing I would make clear is that potentially if you're dealing with matters that are greater than 12 months ago, I think it's just important that we all acknowledge that recollections may have faded. Things that the complainant is claiming, people might not necessarily remember. The first thing I would do though is just sense check with the employee. Why are you raising it now if they've not raised it previously, just to try and understand where they're coming from in that regard. But I wouldn't necessarily say, no, we're not dealing with it because the result is greater than 12 months ago. So I wouldn't take that automatic approach, if that makes sense. And sometimes we've dealt with complex matters where we will even seek legal advice ourselves just to sense check when you're dealing with those types of issues where complaints are raised 12, 18 months about issues that took place 12, 18 months ago. But certainly I don't just make an automatic note. I'm not doing that. I would ask the question, particularly as they've been away from the business on sick leave, essentially long-term sick leave.
So we've got an answer to the other one, Nathan. So the grievances, it says independently from various people against one person. Do you want me to go back to what the original question was?
No, because I mean that sounds more like a collective grievance to me, and I'd be inclined to treat that as such. If the issues are all kind of related, so for example, if say you've got 3 individual complainants and they're raising similar issues about conduct, for example, and it's related conduct, then I would look at treating that as a collective grievance and then investigate accordingly.
Okay. Right, Alison's asked, you mentioned that you record the meeting. I assume you have to get everyone's permission to record the meeting and do the notes, then have to be verbatim, as without the recording they would not need to be verbatim.
Well, no, we don't. So we will take a recording, but we don't type up a verbatim transcript. What the recording does is allow us to type up the notes. So we don't do what we would call it's probably more an intelligent verbatim. So we don't put in all the waffle, we cut that out. And what we say to the all the ums and the ahs and the yay, nay, we cut all that kind of waffle out, and then we just leave the rich kind of data that we need. So we say to individuals that we won't provide you with a verbatim transcript. And what we would do is make sure we provide you with an accurate transcript that fairly reflects the key discussion points of this meeting. And the recording enables us to do that, because what you haven't got is someone scribbling down by hand and then having to go away and type that up. And actually what we found by recording, we changed our practice in terms of moving away from having someone join and take handwritten notes to recording. I still have a notice. If I'm doing it online, a note taker will still be there in person to act as a witness. But we will, and that's not imperative if you are recording it, but it's just the way we work. That's how we like to conduct those meetings. But the recording does mean that what's produced is very accurate. And now we actually don't get any challenge on the notes that we provide. And that's in the last 12 months. It's cut down on all the one before, when we were typing up handwritten notes, for example. You would always get a number of queries, because the reality is, I mean, I'm sure all of you, I can remember the days when I would be back in corporate, sat in the disciplinary taking, notes by hand and having to go away and type them up. You can only capture so much information. And so now what we find is that the accuracy of what we produce is very, very good. And also, again, it's always a contentious point. You might speak to some employment lawyers will go, absolutely not, I don't recommend you record. Our viewpoint is this. At the end of the day, what is said in the meeting is said, and we have nothing to hide now. I appreciate some people will raise concerns about, what if I have a line manager that says something inappropriate? Then our view is that we need to make sure they're trained. And if you've got an HR representative present, you can hopefully help them manage that situation, manage the meeting itself. But I mean, what we do when we work with clients now is, and we're recording meetings, and if the client themselves are handling either the grievance or the disciplinary, we will make sure we work with that client to structure the meeting and to make sure they have a clear framework of questions that they're going to answer, so that no line manager goes in blind. They have a comprehensive set of questions that is relevant to the complaints that are being made. But yeah, I hope that answers that question. But recording for us now, and it's reduced. I can't remember the last time we did look at it, but and I can't remember the numbers. But in terms of efficiency, recording and having those recordings typed up into a transcript has saved us hours of time, because you've no longer got somebody going through handwritten notes and preparing them. So it's made us much more efficient.
So Yvette's asked, what about ex-employees, in brackets the last 2 months of leaving, who've raised concerns via email without stating the raising a grievance? Could we say that we will look into their concerns internally without giving them a formal outcome response? Yep.
Yeah, because they're no longer an employee. So you could say, well, look, we've noted your concerns and we'll investigate that accordingly internally, but then you wouldn't necessarily then need to go and write to them and go through the full grievance procedure with them, because once they've left, they're no longer an employee.
So Caroline's asked, do you have to communicate to witnesses in advance of the meeting with them, explaining the exact nature of the reason you are calling them as a witness. For example, the details of the grievance raised.
No, I mean, we always, just as a matter of good practice, we'll invite people to investigation meetings, and we will explain that a grievance has been raised, and we'll give them very top line information around what the complaints are about. But we don't go into any detail. We do that in the meeting itself, but we do put that in writing to them. And the reason we give them that the kind of the top level information is that they can then prepare themselves ahead of that meeting. So if they have been witness to things, and they've got relevant information they might want to share, it could be emails or so on, it gives them an opportunity to maybe gather some of that in advance. But yeah, we do give, but we don't go into great detail. And again, in that communication, we cover off confidentiality. So we're very clear about confidentiality, and that needs to be adhered to.
So Caroline's asked, I know of someone who's been waiting for a grievance outcome for 7 months. They keep being told it's delayed, but there's no definitive timescale. Isn't this wholly unreasonable?
Yes. Well, yes, I'm saying that. Yes, that sounds wholly unreasonable. I don't know the detail, but I can't imagine why any outcome should take an organisation 7 months to reach. So that would be odd to me. That's certainly not the norm. And we deal with really, we've dealt with very complex matters over the years for various organisations, and it's we accept sometimes we've gone over that. If the policy says we'll communicate the outcome in 10 days, and we know it's going to be longer, we communicate that. But I think the longest delay is an additional 10 days that I've dealt with, where instead of 10 days it was 20. But we communicated that to the employer. We set out why. It might be to do with the amount of information that you have to review and reflect on, for example. But yes, 7 months does seem excessive. I'd love to know why. I'm just being nosy now, but that's very excessive. It's certainly not something we would advise unless you can absolutely objectively justify why that would be the case. It's not something it doesn't sound reasonable to me.
I've no more questions at the moment, Nathan. Has anyone got any other questions that they want to add? We've got a few minutes that we can cover them if there's any others. Covered a lot there, Nathan. Everyone's thinking about what you've said.
Well, I've stunned them into silence. I hope it was helpful. I realise, excuse me, every time I come on, I've always got some form of cold or something. Have you noticed though? I'm always like just making sure my voice doesn't go. I hope it was informative. Again, it's not gone into wide-ranging aspects of employment law, but it's more about managing the process today. And for me, I think that if you can get the process right, you should hopefully get a good outcome. I'm not saying that everyone's always happy. When I've just funny enough this morning drafted an outcome letter to an employee on behalf of a client, and I've heard from the client before coming on that the employee had read that outcome and they're unhappy. And of course, that is sometimes the case. That you can't necessarily please the person who's making the complaints. All you can do is find in favour of the evidence, and that's what we always say. We will go with the evidence and the facts take us. But yeah, I hope that was helpful.
Right, there's a few other bits coming, Nathan.
Yeah, it's fine.
Going back to what the question around where you'd said you thought it was more of a collective grievance. Jo has come back to say that she's been advised to start the investigation as a chat, but she sees it as a formal investigation which would be treated as such.
Yeah, I mean, here's the it always makes me laugh. I mean, essentially, the investigation is what we would consider to be the formal process. It's just fact finding. So although we talk about it as like a formal process, that's why we say employees don't have the right to be accompanied at investigation meetings, because it's not a formal meeting in the sense of what a formal hearing would look like. So yes, you might say that the investigation process is a formal investigation, but essentially what you're doing is you're fact finding and you're gathering information and evidence which you can then present to back to the organisation. And in that, I would expect whoever's doing the investigation, if they're not going to hear the grievance, that they would be making recommendations about whether there is substance or merit to the complaints being made. But typically, and this is why I would say with the grievance, ideally, the person investigating will be the person that hears the grievance. But yeah, so absolutely, I appreciate what you're saying. It's a form, have have a word or conversation, but essentially just arranging to meet with someone and take down the details of information that they might have that could support any complaints made. That's essentially all you need to do. So don't get too hung up on the difference between formal and informal, if that makes sense.
So Caroline's asked, what level of documentation should be made and kept at the informal stage?
So when we say the informal stage, we talk about where you are dealing with your grievance informally, or we talk about an investigation again?
That's from Caroline. I don't know if you're able to expand, Caroline.
Sounds like she's saying dealing with it informally. Essentially, if you're dealing with something informally, it might be that you've had a letter of complaint.
Sorry, Nathan, she said informally.
Oh yeah, fine. So if you're dealing with a grievance informally and the employee agrees, then they may have raised their complaint in writing. So you would keep that documentation. If you're going to have informal conversations, you're not necessarily going to record the ins and outs of those conversations. But what I would say is you would be making a record of the decision-making process and what action you took, so you have a record on the personnel file. So if you've got the employee's complaint, it's then been agreed that you're going to deal with it informally, you would confirm that in writing to the employee. So if they've agreed, which is what I do, if an employee says, yeah, I'm happy for it to be dealt with informally, I will write to the employee and summarize that conversation and say, we've received your complaint, we've had a conversation, we've agreed that it can be dealt with informally, you've agreed, and therefore we're going to take the following action. And you just will set it out in bullet point format is what I would do, and then you keep that as a record. So essentially the informal stage, which is always preferable, is not about keeping war and peace in terms of documentation. It is just about you having a clear record of what you did with that complaint, and that all parties agreed that informal action was actually appropriate in the circumstances.
Okay, so we've got, if an employee has a grievance and appeals and the appeal process is exhausted, they then raise another grievance which relates to the first grievance. Is it reasonable to say it can't be investigated even if new evidence of previous grievance is raised?
Oh, that's an interesting one. I mean, if the grievance is concluded and the employee had the opportunity to present any evidence, which they would have done if you invited them to a grievance hearing, you could argue, and they've appealed and you've heard the appeal, then you would be within your rights to say there is no further recourse to this, because unless you've got more than a one-stage appeal process, which ideally you wouldn't do. Although we've got a client that has a two-stage appeal process. What I would say is once you've concluded the appeal, the matter's concluded. I'd be interested. I mean, when you say new evidence, I might be interested to know what that new evidence is, and I would sense check potentially have we overlooked anything. But typically, my viewpoint would be if you've heard the appeal and you've upheld the original outcome, and you're not overturning anything, then once you've heard the appeal's the appeal. So I wouldn't look to offer them another stage to the process.
This one will make you laugh, Nathan. So Caroline's responded about to satisfy your curiosity where the outcome hasn't been given.
Oh yes.
It's from the police.
Oh, that doesn't surprise me. I did wonder, I thought it's either going to be a borough council, the NHS, or the police. And if anyone's worked for the NHS or the borough council, that's not me being making any derogatory comments about them, but it is often what we see when we've done work for borough councils and the NHS, and those processes, it can be very long and protracted. Sometimes it is genuine, that is because of the complexity of the situation. It might be the seniority of the person and the issues at hand. But yeah, sometimes, I've seen issues in the public sector where they have dragged on for months and months and months, and for no good reason really, which is such a shame, because often the people that are party to that process really struggle, and it impacts their mental health, and actually the working relationship breaks down. I mean, I would say if you've made someone wait 7 months to give them the outcome of their grievance, you would argue what damage does that do to trust and confidence. So but yeah, when you said that, doesn't surprise me.
Okay, there's no other questions. I'm just conscious of time, Nathan. Is there anything else you want to say before I just do a quick close?
No, I hope it was really useful. I appreciate that there's probably some awesome, amazing HR people on the call. There might be some business owners or line managers on the call who aren't familiar with the process. But if you are in HR, then I've probably just confirmed lots of things that you already know. But I hope it was useful. I do love spending time with you guys doing these sessions, because sometimes actually when we have the engagement, I learn stuff about what other people do and their approach. So yeah, it was nice to be able to spend some time with you. So thank you very much.
Okay, thanks very much to everyone that's joined today. We will send out some correspondence to everyone that signed up for the event, and I'll also put a post onto LinkedIn. So if you would like a copy of the recording and or the slides, then please put a comment against the LinkedIn post. Our next event is next Tuesday, the 10th, and is a virtual boardroom called Commercial HR. What does a CEO look for in modern HR departments? And a link to sign up to this will be included in the email. We'll also be sending out a quick feedback questionnaire to everyone that's signed up. So if you've got a couple of minutes to complete it, then this will be much appreciated. We've also got accountancy recruit, FD recruit and executive recruit within the group if anyone is recruiting. But finally, I would just like to say a massive thank you to Nathan for your time and effort in putting the event together, and also to everyone that's signed up and tuned in. Appreciate it. Thank you.
Thank you, Joe. Thank you to everyone who attended.